today's webinar is essentially about clearance denials or suspensions and how that can impact your federal employment. As she mentioned, my name is Ryan Nerney. I'm the managing partner of the Southern California Ladera Ranch office for Tully Rinke, and I primarily practice both security clearance and federal labor and employment law. Just as a disclaimer, the views expressed in this publication are mine and do not imply endorsement by any U.S. government agency. This is for information purposes only and should not be construed as providing legal advice. So as Brittany kind of went over at the beginning introduction, today what you'll learn is essentially what is an indefinite suspension, because ultimately that's the primary action that agencies take if one's security clearance is impacted for a federal employee. Why one of the most common reasons for an indefinite suspension adverse action is a security clearance related issue. How does a suspension or revocation of your security clearance cause an indefinite suspension? The limited defenses to an indefinite suspension, and when I say limited, I mean limited. It's very limited for that aspect. The case law and regulations for indefinite suspensions based upon security clearance suspensions, what those are and kind of what those look like. Options for resolutions to an indefinite suspension, and then essentially appeal options for Marriage System Protection Board. So this is going to be kind of a hybrid webinar today about security clearances. So we will dabble a lot in the security clearance realm, kind of how a security clearance impacts federal employment, but ultimately kind of the actions that the agencies take if one's security clearance is actually impacted. So first, what is an indefinite suspension? So essentially, as simple as I can make it, an indefinite suspension occurs when a federal employee is suspended from all duties and employment activities without pay for an undetermined amount of time. So when I say undetermined, that just means that we don't know how long it's going to be. However, there has to be some sort of end. And bringing to the next aspect here, Jones versus Department of Army kind of gives what that is, which is in order to be a valid indefinite suspension, there must be an ascertainable end, meaning that there has to be some sort of condition that is able to be met that will bring the suspension to a conclusion. So it's indefinite suspension. Indefinite means that we just don't know when it will end, but there is some sort of action that occurs in order to end it. So for instance, an agency can't just say, okay, you're on indefinite suspension and that's it. They say you're on indefinite suspension until, for instance, for security clearance, there's a final adjudication of your clearance from some sort of adjudicative body. I'm going to be talking a lot about the Department of Defense and the Department of Defense affiliates because that's a lot of what we see. But this is applicable to all agencies. Some agencies have a little bit different process for security clearances and kind of how they adjudicate that. Some offer hearings, others offer a response first and then a hearing, one or the other for some agencies. But ultimately, it comes back to if you're a federal employee and your clearance has been locally suspended or denied, or even suspended from, let's say, DCSA, Defense Counterintelligence and Security Agency, without a final decision, the agency can take action to place you on indefinite suspension. So one of the most common reasons for an indefinite suspension, as I mentioned before, is security clearance related. There is another option for this to be placed on indefinite suspension, which we see sometimes, which is if an employee is being investigated or prosecuted for a criminal offense, then sometimes agencies place those individuals on indefinite suspension until there is some sort of resolution to that criminal offense, whether it's dismissed for lack of evidence, whether it's a plea agreement, what have you. And depending on what the outcome of that is, the agency can take further adverse action or not. But that's one of the reasons. The more common reason that we see is that a security clearance is suspended or revoked in some cases pending an appeal. Typically what we see for federal employees is there's some sort of security concern that happens. Maybe somebody popped positive on a drug test, or They failed to report foreign travel, or it could be criminal related. They were arrested, or they had a DUI or something like that, and that triggers a security concern, which whether they properly reported or not, anything that is a security concern, should be reported depending on the circumstances. But essentially, that would trigger some red flags or security concerns to the agency, and the agency would then take action to locally suspend the clearance. Now, when I say locally suspend, I mean that particular agency, that particular division of the agency, that particular command. If it's like Department of Navy or something like that. So whoever is the commander, or the person who runs that particular location, they have the power to locally suspend a security clearance, pending a final review. So just because a commander or a local agency head or somebody like that takes action to locally suspend a clearance, that doesn't mean that's the final decision. In fact, they don't have the power to do that. Specifically talking about the Department of Defense, the final decision for security clearances rests with the Defense Counterintelligence and Security Agency, or if you end up going to an appeal process, the Personnel Security Appeals Board would have the final say if DCSA decides to revoke the clearance at that point. So anyways, that local suspension doesn't necessarily even have to be followed by other organizations. But for the most part, if there is a valid security concern, that would need to be investigated and then adjudicated. And then that would be the ascertainable end that I was talking about before. So, the underlying reasons for security clearance revocation are not typically charged in indefinite suspensions. It's just the security clearance suspension itself. So essentially, that prevents an employee from meeting a condition of employment. What that means is that if your position requires you to obtain and maintain a security clearance, even if you don't use it, even if you're not routinely working with classified information, if your position description specifically indicates that you are required to have a security clearance at some sort of level, and that's locally suspended, then at that point you don't meet a condition of employment. And then that's what the charge is for the indefinite suspensions. As I mentioned before, the most common charge is a failure to meet a condition of employment. So again, essentially because your clearance is suspended, which it typically entails the removal of all access to classified information, material, locations. That means you're unable to perform the essential duties of your position, or at least that's the interpretation of it. And therefore, indefinite suspensions are used in lieu of removals because there's no final determination that's made. So agencies don't typically go straight to removal if a clearance is locally suspended, because there's a number of cases that kind of essentially prevent them from doing that unless the conduct is extremely egregious, and they charge you with not just the failure to meet a condition of employment, but the actual conduct itself. So indefinite suspensions are kind of used as kind of like a stopgap, if you will, to wait to see if the clearance is going to be revoked. If the clearance is ultimately revoked, then at that point, agencies will likely start removal proceedings, because at that point there's a final determination, and then again, you won't be able to meet a condition of employment. If the security clearance is not revoked and it's found in your favor, then at that point indefinite suspension will be lifted along with the actual clearance, the local clearance suspension. So in order for a security clearance suspension to be enacted, an agency or military command must have a legitimate concern that continued access to classified material or locations would be detrimental to government interests. This is a very, very low threshold. It could be anything that would raise some sort of concern. It could be something where, they came to you, there was maybe another coworker that came to the supervisor and reported that you used marijuana on the weekend. Something like that. It wasn't at work. You didn't appear under the influence at work. So the overall security clearance issue may not be that dire, However, use of illegal substances is against federal law, at least marijuana in this case, for the time being. And if if that's reported to a security officer or something like that, then the next step would be to, if it does raise to the level of a heightened concern, that could lead to a local clearance suspension. Now, typically, the agencies would have to follow a certain procedure in order to enact that local suspension. That typically starts with an incident report. That's typically placed in an employee's defense information system for security, or scattered castles. DISS is usually for DoD or DoD affiliates. Scattered castles is usually for the intelligence agencies. There's other platforms, for potentially other agencies, but those are the prime ones. And what this does is this triggers an investigation by the investigators and adjudicators for security clearances for that particular agency. And when the agencies do this, they typically provide some sort of notice to the employee, basically putting them on notice that there's a security concern. They're going to report the security concern to DISS or whatever the actual adjudicator is or adjudicating body is, and they typically give a certain period of time for that employee to provide some sort of response, feedback, whatever. Not all agencies do this. They're supposed to, but not all agencies do. Some just say, here's a notice, we're putting you on notice, here you go. If you want to provide something, we can, but that's not going to change our decision. Other agencies give you an opportunity to address the concern before they submit an incident report. But for the most part, the agencies will just put you on notice, give you a few days to provide some sort of response. But overall, they probably still will submit the incident report. And if you do submit a response, they'll submit that response with the incident report, and then ultimately leave it up to the adjudicating body to make a determination. Sometimes those determinations can be quick. Sometimes they take a significant amount of time depending on the allegations. But as previously mentioned, once a security clearance is suspended and a clearance is a requirement of your position, you can be placed on indefinite suspension without pay pending the final adjudication of your clearance. And that's the ascertainable end that I was talking about before, is the final adjudication of your security clearance. A clearance suspension usually follows, self-reporting security concerns, some derogatory information discovered through the continuous evaluation program that is currently in place right now. As I mentioned before, another employee reports legitimate security concerns, or just discovered through routine processes or procedures, random drug tests. If you're trying to re-up for your security clearance, maybe get to a higher level security clearance, you have to fill out a new SF-86. Something like that could potentially trigger some concerns. So any of those things can potentially lead to, that heightened risk, the clearance suspension, ultimately the indefinite suspension that follows. So once your clearance is locally suspended and you're issued an indefinite suspension, and just as a side note, that could happen all in one. A lot of agencies issue several notices within a short period of time, sometimes hours, sometimes days, in very quick order, puts you on notice of your clearance suspension, then ultimately lets you know that the incident report is going to be submitted, and then immediately thereafter place you on a definite suspension until that final decision is done. I've seen agencies issue all three of those notices within maybe like an hour. So it can happen very quickly, especially if agencies don't really want to deal with the situation, if you will. And they just want to say, okay, here's a third party, you deal with it, DCSA, and then we'll get back to you. And we'll figure this out once you make a determination on the clearance. So, but as I mentioned before, once you are placed on indefinite suspension, there's very limited defenses for that. And when I say indefinite suspension, I'm specifically talking about for the sole reason of your clearance being denied or revoked or suspended locally. because at that point, again, you fail to meet a condition of employment. If there's other issues related to, misconduct or something that's also included with that indefinite suspension, then that's going to be potentially a different process. You may have, a lot more defenses to that. But with a narrow situation, which I have seen quite often recently, with the narrow situation of a security clearance suspension leading to a failure to meet a condition of employment, and ultimately indefinite suspension, there are very limited defenses for that. The underlying reasons for security clearance suspension cannot be reviewed or taken into account by MSPB or anything like that for the indefinite suspension. They can just look at what the charge is, which is a failure to meet a condition of employment. I'll get into the specifics of that and what those requirements are in a minute, but ultimately they can't look at the underlying reasons. So if you submit a response to an indefinite suspension, which the agency is required to give you, just like any other adverse action under Chapter 75, agency has to give you due process. Due process rights afforded to an employee whose access to classified information has been suspended specifically include notice of the agency's determination regarding the employee's access. If there is a statement of reasons, something like that for the determination, and then an opportunity to respond, that's for the clearance aspect. For the actual indefinite suspension aspect, it's same due process applies for if you would be removed or demoted or suspended for more than 14 days, anything like that, you're required to have sufficient notice. They can't be enacted for 30 days. As you see right there, this is under 5 U.S.C. 7513B. At least 30 days advance written notice, unless there's a reasonable cause to believe the employer has committed a crime for which a sentence of imprisonment can be imposed. Stating the specific reasons for the proposed action, a reasonable time, but not less than 7 days to answer orally and in writing, and to furnish affidavits or other supporting evidence, and then be represented by an attorney, and also receive a written decision for the specific reasons at the earliest date, but they can't be before 30 days. So essentially, it's the same due process you would get with any other type of adverse action under Chapter 75. The only difference is that you can't make arguments as far as the underlying reasons for the security clearance suspension. So if you feel that the clearance suspension was improper, that's not really something that you can argue because MSPB ultimately can't look at that. Now going to the other kind of limited defense you have. So you have due process issues. So if the agency doesn't follow the proper due process, then that could be a defense in order to get the indefinite suspension overturned. There's also an aspect of harmful error. So harmful error issues occur when any procedure or process is not followed or properly followed based upon the agency's own regulations. In order to prove harmful procedural error, you got to prove that the agency committed an error in the application of its procedures that is likely to have caused the agency to reach a conclusion different from the one it would have reached in the absence or cure of the error. That last part is important because there could be a harmful error. There could be something that the agency engaged in that violated their own regulations. But if that violation of the regulation would not have changed the ultimate outcome of placing you on indefinite suspension, then ultimately that's going to that argument for harmful error is going to fail. So it has to meet those two aspects, which again makes it kind of difficult because ultimately if there is a security clearance issue or a security clearance concern, even if they didn't follow the proper procedure to give you an opportunity to, let's say, respond to that, respond to the clearance suspension, most of the time, unless there's just a complete egregious error, most of the time that's not going to be enough to show that that the indefinite suspension should not have at least been issued or enacted, because ultimately agencies err on the side of caution, and security clearances and national security are a different beast, if you will. And a lot of times agencies and courts will err on the side of national security, because, that's an important aspect to protect. That's kind of the limited defenses that you would have. Essentially it just boils down to, did the agency follow proper due process, giving you notice, those types of things, which sometimes agencies don't. Maybe agencies feel like they don't have to for one reason or another. If that's the case, that's a valid argument for a defense for lifting the indefinite suspension. And then harmful error, like I said before, which is also difficult because you have to show that it would have changed the outcome, which most of the time you can't. So again, defenses are very limited when it comes to indefinite suspensions based upon security clearance suspension and ultimately a failure to meet a condition of employment. These are some of the general cases and regulations that are applicable in these types of cases. As I mentioned before, Department of Navy versus Egan, that essentially indicates that the MSPB does not have the authority to review the underlying reasons for the clearance suspension or denial or revocation. So that's a big case. If you're in the security clearance realm at any shape or form, you've probably heard of Department of Navy versus Egan. Very big case, and that is a case that basically provides rights as it relates to security clearances in general, and kind of review rights for those. Jones versus Department of Navy, I mentioned that before, determined that due process is provided if the agency furnishes an employee with some indication of the reasons for the agency's decision to suspend access to classified information before placing an employee on indefinite suspension. This comes in literally just a notice saying, hey, we understand there's been some misconduct, and we're going to locally suspend your clearance. Now, there's some gray area there, but realistically, agencies kind of have some leeway on what they can and cannot, disclose. They can go as vague as, there's some guideline B allegations that we have, guideline E allegations that we have, which are a security concern. You got 3 days to respond. We're going to submit an incident report, and that's the notice. That's it. So very, very low threshold that they have to meet for that particular case. Same thing, King versus Alston. Agency has to provide minimal due process. Hesper's Department of State provides the board's authority to review, again, only whether the employee's position required a security clearance, whether that clearance was denied or revoked or suspended, whether the employee was provided with procedural due process, and whether a transfer to a non-sensitive position was feasible. So I'll get into that in a second as far as what that actually means. Indicating if a transfer to a non-sensitive position is feasible is not a requirement that an agency find and locate and actually put you in a non-classified position. That case does not say that. They just have to see whether it would be feasible. I could say more than the majority of the time an agency indicates that it's not feasible, whether it's because location, whether it's because, undue hardship, whether it's just because, various different reasons. But again, this says whether a transfer to a non-sensitive position is feasible. It doesn't say whether it's feasible and that they're required to actually place somebody in that position. They only have to determine if it's feasible. So an agency theoretically can come in, and I've actually seen this before, where they say, yeah, it's feasible that we can put them in a non-classified position, but we're not going to do that. We're just going to wait it out. And that's, unfortunately, that's realistically what that case says. This case is back in 2000. So I mean, it's been 25 years, and this case is still relevant. So there hasn't been any valid arguments to that at this point. Excuse me. As I mentioned before, 5 USC 7513. This ensures employees provided statutory procedural due process protections. I already went over all 4 of those points before. I'm not going to hit them again, but that's the main one for indefinite suspensions. For McGriff versus Department of Navy, determine that due process requires the opportunity to make an effective reply to indefinite suspension. but an agency may indefinitely suspend an employee pending determination on security clearance issue. This just gives the agency the power to kind of do what they've been doing. And then an extension, Cheney kind of extends the Egan aspect or findings, which also kind of expands that to indefinite suspension. So in 88, you had kind of more of the overall clearance suspension, denials or revocations, and Cheney kind of extends that to just a suspension of security clearance at the local level. So basically from 2007 up currently, that case kind of gives the agencies, the power to do what they're doing. And I mentioned before, Jones versus Department of Army, this is the ascertainable end, which we were talking about. So again, an agency can't just place you on indefinite suspension. There has to be some sort of ascertainable end. But that ascertainable end, especially for security clearances, which, could take anywhere from 2 weeks to 2 years, is why it's an indefinite suspension, because there is an end. We just don't know how long that end is going to take. And then Ryan versus DHS, this was Fed Circuit 2015, determined that it matters not the basis for the clearance suspension. If that changed over time, that doesn't require a new notice for these individuals. Essentially, if there's a pending adjudication or investigation for a security clearance, if those issues have changed, you can notify, the adjudicating body, but that doesn't necessarily mean the agency would have to lift an indefinite suspension if those circumstances have changed. Because again, that kind of goes back to looking at the underlying reasons for the clearance suspension, which Egan and Cheney basically indicates that the MSPB cannot do. So how to resolve these? Very limited ways that you can resolve these. As I mentioned before, placement in a non-classified or non-sensitive position. Again, the agency is not required to place an employee in a non-classified position. They must only determine if it is feasible. If there are no open positions, you not meet the qualifications for the position, or if it would cause undue burden on the agency, or even something that says, it's just not something that's in the cards at this point, something very, very minimal and small like that, then it would be determined that it's not feasible to transfer to a non-sensitive position. And again, the requirement is not that they actually have to do that. It's just that they have to determine if it would be feasible. So there's no argument to say that, or there's no case law, I should say, that says that they have to put somebody in a non-classified position. However, sometimes when you get the indefinite suspension, you can always make that request. Sometimes agencies are willing to do that if you're a good worker, if you do good work, if you're, maybe working on a project that's important but has a non-classified element to it. Any of those circumstances potentially could lead to being placed in a non-classified position. So looking and requesting something like that, if an indefinite suspension is issued, is something that potentially could happen. Answer is always going to be no if you don't ask. So, it's something that potentially could be looked into. Also settlement as well. If this is your particular situation and this situation works for you, you could potentially resolve indefinite suspension through a resignation with a clean SF50. As I mentioned before, transfer to another position that doesn't require clearance if feasible. You can also speak to HR about obtaining interim employment while you're waiting for the indefinite suspension and ultimately the clearance issue to be resolved. Not every agency allows that. Some require specific paperwork. Some require, it not to have anything to do with your job that you were working on with the federal government. That's something that each agency is unfortunately not the same in. So you would have to look at your particular agency, speak to your particular HR people if that's something that you could potentially do. And then ultimately the resolution would be a clearance determination. As I mentioned before, clearance issues can take anywhere from 2 weeks to 2 years to resolve. If it's favorable, then the indefinite suspension should be vacated and employees should be placed back into their previous position that they were before, or a comparable position if their previous position was backfilled or something like that. This could happen at any stage in the process. This could happen even before the indefinite suspension is enacted, which I've which I've seen before. This could happen a year down the line. It could happen really at any point. It's just a matter of that ascertainable end, which I indicated before, which is a favorable determination by the adjudicating authority for your clearance. Now, on the flip side, unfavorable decision. So again, that's an ascertainable end. If the decision is unfavorable, meaning that the decision is upheld to revoke your clearance, then at that point you'd likely be removed based upon a failure to meet a condition of employment. Now, there is an appeals process for the security clearance aspect, right? So I mentioned an incident report that would be submitted through DISS or a comparable platform. If there is a determination that there is some sort of security concern that raises, that concern is a heightened risk, then at that point you do have due process rights on the security clearance side as well, which is to receive something called a statement of reasons, or other agencies call it something different, a summary security concerns for the Department of Energy, things like that. But you would be able to obtain that, respond to it in a certain way depending on the agency. Usually it's in writing and then a hearing, and then ultimately that will give you your due process to fight the security clearance aspect. And all this can happen while you're still on indefinite suspension with the agency. So, the quicker that you can get the clearance determination resolved, hopefully in your favor, the more quickly you can get the indefinite suspension resolved as well. And as a side note for that, you always have to have a sponsor for your security clearance. So if at any time you leave that employment, you decide to quit or something like that, then at that point, whatever the adjudicating authority is or adjudicating body will lose sponsorship or will lose jurisdiction, for adjudicating your clearance. That usually is a major red flag. It's called the loss of jurisdiction. And it's really limited ways to get out of that. You either get another sponsor for the clearance, they pick up where they left off with the adjudication of that clearance, or if the incident report is not valid, you could potentially petition that particular organization to remove the incident report. Very difficult to do that. You have to have extremely solid evidence in order to do that, but that's also a way that you could potentially get that loss of jurisdiction resolved. But if you quit while the clearance adjudication is ongoing because you just don't want to deal with the indefinite suspension anymore, just know that if you lose sponsorship, the adjudication of your clearance will stop at that point as well. Now, if you are placed on indefinite suspension, meaning that it's actually enacted or effective, then at that point, what you can do is you can file an appeal with the Merit System Protection Board. I already went over the limited aspects of what MSPB can look at. But essentially, you could file within 30 days from the effective date of the decision to enact the indefinite suspension. All the information for that is found on the MSPB website. But again, as I mentioned before throughout this presentation, MSPB has limited jurisdiction over what they can look at. So again, they cannot look at the underlying reasons for the security clearance. They can only decide if the indefinite suspension is valid based upon the reasons given by the agency, so failure to maintain a condition of employment, and that the agency afforded that employee the appropriate due process, as we previously discussed. So very limited options as far as appeal goes. Excuse me. The best way is to resolve an indefinite suspension if it's based upon a clearance suspension and a failure to meet a condition of employment because of that, is really to focus on the security clearance aspect and get that security clearance aspect resolved. That's the easiest way to do it because, again, once that clearance issue is resolved, if it's resolved in your favor, the agency has to place you back in that position or a comparable position. And that's the ascertainable end according to the regulations and the law. The last aspect of this is back pay. I get this question quite a lot. If I'm placed on indefinite suspension and ultimately my clearance is reinstated, am I entitled to back pay? Essentially, no. there's no property interest in a security clearance as there is for employment. And all of this, if it's based upon a security clearance suspension and ultimately indefinite suspension because of that, the MSPB has routinely and consistently rejected claims for back pay when the security clearances were ultimately restored. So even if it determines that those the issues that caused the local suspension of your clearance were mitigated, that doesn't mean that there was not a legitimate reason or a valid reason to ultimately locally suspend that clearance. As I mentioned at the very beginning of this presentation, they only have to provide a specific, concern, right? It just has to be some sort of concern that they would have that could potentially be a security violation. Even if you don't think it's valid, even if you feel that, you're being attacked or something like that, ultimately they err on the side of national security. And if there is some sort of security concern, then the agencies typically hide behind that. And ultimately, if that's the case, you're not going to be entitled to any type of back pay. So, the general rule I would say is that if you are indefinitely suspended because your clearance is suspended and you're placed on indefinite suspension, sometimes, as I said, these can go for a couple weeks. Sometimes they can go for a couple years. Excuse me. If that's the case, you're not going to be entitled to back pay for that entire 2 years. If that's the reason. So, that's kind of the gist of everything as it relates to security clearances having an impact on federal employment. Excuse me. So, for the most part, that's kind of, what would happen in the event of a local security clearance suspension. And I typically say local because that's mostly what I see. There are circumstances where DCSA can suspend your security clearance while not making a final decision on that clearance. Sometimes there's allegations that are so egregious that DCSA decides to suspend the clearance at their level, which means that your command has no say in that. They suspend at their level, but it's not a final decision because they have to look into it. They issue a statement of reasons, have to go through that entire process in order to make that final decision. So they can suspend your clearance at that level as well. But for the most part, it is local clearance suspensions that kind of cause that snowball effect of the indefinite suspension, being enacted. So there are a few questions that we received before here. I'm going to go through a few of them. I know I addressed a number of them here, but within the presentation, but there's a couple of questions here I think would be beneficial. Is there a need to apply for a job that requires a security clearance if you had a clearance that was revoked over 10 years ago? There's always an opportunity. I don't know what the reasons for revocations are, but there are processes you can go through to what they call reapplying for a security clearance. Most agencies require you to wait 1 year before you can reapply for security clearance. Others are sometimes 2 years, depending on the circumstance, but most are 1 year. I know DOD is 1 year. And then at that point, you'd have to address the allegations that previously caused the revocation. I've even seen circumstances where individuals have had their clearances revoked for 10 years or longer, and they reapplied for a clearance, and they still had to go back and mitigate those allegations that caused the clearance revocation over 10 years ago. So, it is possible to get a clearance, but you may have to jump through a couple hoops in order to do that. That kind of answers a few of those questions in here that we got before. What impact does financial difficulty have on each clearance level? This is more of a general question regarding clearances, not necessarily related to indefinite suspension, but if there are situations where there's like maybe a criminal element to the financial stuff, that could be a cause for a security concern and ultimately, a clearance suspension. Somebody who has financial difficulties, bankruptcy, something like that, it doesn't necessarily mean that there's going to be an issue with your clearance. However, that is an adjudicative guideline that is looked at. and it also depends on each individual's circumstances. Realistically, agencies and the government is looking for delinquent accounts or nefarious financial activities, something like that. So if you have a high amount of debt, that doesn't necessarily mean that's going to be a security concern. If you have a high amount of delinquent debt, then that's going to be something that's going to raise some red flags. Let's see. I already kind of went over the LOJ. If I have a red line on my clearance, how long does it remain? I'm assuming that means a red flag. It remains. I mean, it depends. It depends on the circumstances. The more time that's passed, the likelihood that that's not really going to be a big deal. However, if there's an LOJ, that LOJ is going to remain there for until it's resolved. And that, like I said before, the resolution of that is either to get a new sponsor to have an investigation begin or continue, or to petition. In this case, would be DISS to remove that incident report. But you have to have solid evidence to do that. So the red flag ultimately is going to remain on there until it's resolved in one shape or form. But if there's a change in circumstances, if you reapply for a clearance after a year or something like that, you can provide additional information at that point to to kind of resolve those issues. However, as I indicated before, you need to have a sponsor for a security clearance. If you don't have a sponsor, you're not going to be able to you're not really going to be able to get a clearance. So that's kind of the situation there. There's a couple other questions here in the chat that I can go over. What happens if an employee is removed from office for conduct of becoming a federal employee, but the removal is under appeal to OSC or MSPB? It depends on the circumstances. If that could be reported to DISS, if the conduct or misconduct happened while you're still a federal employee, then typically that agency has an obligation to report that to DISS. So I would say that the typical, and this is kind of by an agency, each agency is a little bit different. But what I would say is that typically if there is some sort of misconduct and that impacts your employment and you do have a clearance, I would say a lot of times the agency does automatically submit an incident report to DISS. It doesn't necessarily mean that they're going to take action to locally suspend your clearance, especially if you're going to be removed. That's kind of a separate issue of employment versus security clearance, because there are regulations that indicate that there are reporting requirements for both individuals who have a security clearance and security officers. So if the agency comes into contact or comes into information that is a potential security concern, that is something that should be reported even if the agency is taking action to remove you. At which point, if you're removed, then that's going to cause a loss of jurisdiction, like I was indicating before, because ultimately that incident report is going to be submitted. There's going to be an investigation that's going to start. However, if you are removed, even if you have an appeal with MSPB, if you are removed, that will cause you to lose sponsorship and ultimately lose jurisdiction. So that incident report and your security clearance, DISS, won't be able to be adjudicated until that LOJ is resolved. Under an indefinite suspension without pay, would an employee be entitled to their annual leave payout? Typically not, because they're still technically an employee. That's something you can talk to your agency about and see if maybe that's something that they're willing to do. Most of the time they can't, because regulations prevent it, because essentially you're still an employee. Sometimes what you potentially could do is, if you can't go a long time without pay, sometimes you can negotiate something before the effective date of the indefinite suspension to use your annual leave. So for instance, you can kind of use, let's say you're placed on a indefinite suspension, but you negotiate something where you can use 30 days of annual leave. So you're going to get paid for those 30 days. And then at the conclusion of you using that annual leave, then the indefinite suspension will be effective. And then at that point, you won't be paid. So there are options and ways that you can kind of address that and do that. But that's something that you'd have to talk to your agency about. What if a person is already adjudicated or completed the discipline penalty for the misconduct? Can they still use that to question clearance? Yes, because they're separate processes. So, for instance, like as I indicated before, agency reports a security concern to DISS. That takes that clearance issue out of their hands. It goes directly to DCSA. So, even if, let's say, you are, something happens, there's misconduct, you're suspended for 14 days, you serve that 14-day suspension. If there's an incident report that is submitted to DISS, then DCSA has the ability to review the incident report. And ultimately, even if the agency says, okay, 14-day suspension, that's it. If DCSA decides that it's a bigger issue related to your security clearance, then at that point, you still have to go through the process. If they issue a statement of reasons, you still have to respond to it. So, again, there's reporting requirements and reporting obligations. So even if the agency handles something on the employment side, the security clearance side is a different animal, and that goes through the particular adjudicating authority. So just because the agency handles something, disciplinary wise on their end, doesn't mean that the clearance issue would be resolved if it was reported and properly reported. I think that's pretty much it for all the questions. So I want to thank everybody for taking the time to attend today's webinar. As Brittany said, there'll be a copy of this. This is being recorded, so there'll be a copy of this for everybody to review if you would like. So thank you, everybody, for attending. I appreciate it.